This is the conditions of copyright. Copyright is an exclusive right granted by law for a specific time period to the author to control the use of their work. In Malaysia, copyright protection is based on the Copyright Act 1987. Malaysia is currently no system of copyright registration. A work automatically protected as soon as they fulfill the following condition. First, sufficient effort has been expended to make the work original in character. Second, the work has been written down, recorded, or otherwise reduced to material form. Third, the author is a qualified person. Fourth, being a work and first published in Malaysia.
Application procedure. The owner of the invention is eligible to apply for a patent. The owner may be an individual or a company. An application for a patent in Malaysia must be filed with the Patent Registration Office of the Intellectual Property Corporation of Malaysia, MyIPO. The application may be submitted to the Patent Registration Office by hand or mail. To file an application in Malaysia, the applicant is required to lodge the following with the Patent Registration Office. First, Form 1 for an application for a patent. Second, a patent specification consisting of a description of the invention, a claim or a set of claims, an abstract and drawings, if any. Next, payment of the prescribed filing fee. Information must be provided in Form 1: name, address, and nationality of the applicants, name and address of the inventor, and priority details. For example, the filing date, application number, and country of an earlier application from which priority is claimed, which this only applies if the applicant has filed an earlier application for the same invention. The earlier application, which is the first application for the invention, is called the priority application, and it must have been filed not more than 12 months before the filing date of the application in Malaysia. In addition, Form 17, which is appointment of patent agent, is also required to be submitted to the Patent Registration Office if a patent agent is appointed, and the statements justifying the applicant's right to a patent if the applicant is not the inventor of the invention.
Procedure for application of trademark. Trademark file a trademark application TM5 form must be submitted through the form of 5 copies together with the TM5 RM250 for each application. Application for different trademark must be submitted separately. If the payment check or money order, postal order must be in the name of the Intellectual Property Corporation of Malaysia. Each statutory declaration must include the certificate application through statutory declaration that the trademark apply for is owned by real applicants. Class of goods. Each application must list the specification of goods or service and the correct class. Application for the different classes in a separate application. Agent service application may be submitted directly by the applicant or use the service of an agent who will act on his behalf. Agent address is the address of delivery for all correspondence. Appointed agent must be a registered agent in a register of trademark agent. Application from outside the country must use the service of the agent. Appointment of agent made Form TM1 for RM13 18 to submit documents supporting documents such as Form 49, the Companies Act 1965 for application by private ownership and partnership, transliteration and translation for stamp bearing the words not Latin or in a language other than English or the national language. The translation should be made and certified by a qualified translator. Registration process Form TM5 file will be given the official receipt and application number. Examination of formality will identify whether the application contains the information as required. If the information is not sufficient, the letter of inquiry is submitted. The applicant was given 12 months from the date of filing to take action. If no action is taken within that period, the application will be deemed to be ignored. In the process of search and examination, each application will be assessed and the applicant receives either a letter of acceptance, Form CD29, or letter of objection, CD70. If objected to by the Registrar of Trademark, the applicant may submit a written appeal or apply for a hearing to prove the registrar that the objection may be ignored. Whereas if an application can be approved, a letter of acceptance, Form CD29, will be sent to the applicant. The applicant must return the signed letter of acceptance as well as RN 415 Trademark will be gazetted in the Gazette to allow third parties to make opposition against the registration. If there is no opposition within 2 months from the date of Gazette, they say trademarks are registered. If any third party file an opposition, the opposition will inform the applicants about the matter. The applicant must decide whether want to defend their trademark application, 90, or consult with the opposition or withdraw the application.